Hi, welcome to another episode from the Lawyer Society Legal Podcast. In this episode, we'll be talking about how and whether Section 24 of the Code of Civil Procedure 1908 can be used to transfer proceedings under 125 CRPC, that is the repealed CRPC, proceedings for maintenance, that is, from a family court to another family court, or from the magistrate to a family court, or from the family court to a magistrate court. Before moving on to the contents of this particular episode, I would like to request you to please rate this podcast show on Spotify. Give us a rating and also do follow us and share this podcast with your friends and colleagues so that we are able to reach more people and create more interesting legal discussions, because that is our intention. We want to reach more people and help more people learn and understand how the legal provisions work, and we want to create an interest in legal reading. Now, if we want to explain this particular topic, we will have to refer to certain provisions from the Family Courts Act. Let us look at Section 7 of the Family Courts Act of 1984, which provides for jurisdiction. As per Section 7, subsection 2, a family court has the jurisdiction exercisable by a magistrate of the first class under Chapter 9 relating to order for maintenance of wife, children and parents of the CRPC 1973. So, even though that particular act, that is the CRPC, has been repealed, now the corresponding chapter from the BNSS of 2023 will be substituted here. So, we have to understand that in this manner. So, when we give this a bare reading, we understand that a family court assumes the place of or jurisdiction of a magistrate court wherever the family court has been established. So, in whichever district a family court is present, it will assume the role of a magistrate insofar as Chapter 9 proceedings are concerned. This can be seen from a bare reading of Section 8, where it reads that where a family court has been established for any area, no magistrate shall, in relation to such area, have or exercise any jurisdiction or powers under Chapter 9 of the CRPC 1973. So, when you give this a bare reading, you understand that in those areas where a family court has been established, the jurisdiction of the magistrate under Chapter 9 of the CRPC has been excluded. So, the magistrate will have other powers under other chapters. He performs his role as usual, but when it comes to the proceedings, that is the maintenance proceedings, the family court will be taking up that responsibility. Now, let us look at Section 24 of the CPC, which provides for general power of transfer and withdrawal. As per Section 24, it reads, on the application of any of the parties and after notice to the parties and after hearing such of them as desired to be heard, or of its own motion without such notice, the High Court or the District Court may at any stage transfer any suit, appeal or other proceeding pending before it for trial or disposal to any court subordinate to it and competent to try or dispose of the same, or withdraw any suit, appeal or other proceeding pending in any court subordinate to it and try to dispose of the same, or transfer the same for trial or disposal to any court subordinate to it and competent to try or dispose of the same, or retransfer the same for trial or disposal to the court from which it was withdrawn. So, a bare reading of the first subsection from Section 24 of the CPC, we can understand that the High Court has the power to transfer proceedings from any court subordinate to it to another court that is subordinate to it. So, when we look at it this way, a proceeding under 125, that is Chapter 9 of the CRPC, is it civil in nature or is it criminal in nature? Can a proceeding under 125 CRPC be transferred using 24 of CPC? Because generally speaking, we will assume that 125 comes under CRPC. It is within the purview of a magistrate. How can 24 CPC be pressed to transfer a 125 proceeding? But that question has already been answered by the Honorable Supreme Court in the case of Ramchandra Agarwal versus State of Uttar Pradesh, reported in AIR 1966 Supreme Court 1888 that is. Also, equivalent citations are 1966 Criminal Law Journal 1514, 1966 SEC Online SC 232. In this particular case, it was said that the expression proceeding used in section 24 does not have a definite meaning. It was said that the term proceeding under section 24 must be given a comprehensive meaning so as to include within it all matters coming up for judicial adjudication and not to confine it to a civil proceeding alone. Now, this was said in the context of transferring a proceeding under section 146 of CRPC, which is section 146 under the CRPC of 1898. So, there it was said clearly that a proceeding under section 146 can be transferred by the High Court or District Court using section 24 of CPC. This principle was subsequently applied by the Madras High Court in the case of Arunagiri versus Kala, reported in CDJ 2005 MHC 794. Useful reference can also be made to another judgment from the Madras High Court, which is CM Buddha Purnima versus K. Gopala Krishnan, reported in CDJ 2020 MHC 864. Where another judgment from the Andhra Pradesh High Court was followed, which is Annavarappu Dhanaraj versus Annavarappu Manikam and others, reported in CDJ 2011 Andhra Pradesh High Court 1035. If you go through all these judgments, you will know that a proceeding under section 125 CRPC can be transferred using 24 of CPC. However, one should also take note of the fact that you cannot transfer a 125 proceeding to a subcourt. You can transfer a 125 proceeding to a magistrate court or to a family court, because these two courts have jurisdiction to hear the matter. Whereas you cannot transfer the same to a court that does not have jurisdiction. For this, you can refer to the principle explained in the case of N. Paktavakshalam versus K. Pramila, reported in CDJ 2017 MHC 1038. If you refer to the principle explained in this particular case, you will know that you cannot transfer the 125 proceeding to a court which does not have jurisdiction to try the same. So, since a family court, wherever it has been established, has the jurisdiction to try a 125 matter, you can transfer it to a family court or to a magistrate court, because a magistrate court has the jurisdiction to hear a 125 matter. But you cannot transfer the same to a district court. Section 24 allows you to transfer a 125 proceeding, but it doesn't mean you can transfer it to a court which does not have jurisdiction to hear the same. I believe if you read all the judgments I have stated in this particular episode, you will understand the basic principles underlying transfer of 125 proceedings using section 24 of the Code of Civil Procedure 1908. I hope you found this episode to be useful. Do follow us on Spotify and also do subscribe to our channel on YouTube. You will find the link down below in the description, and you will find all our links down below in the description box. You can also leave your email ID to receive our newsletter. It will be helpful for you. I write very interesting legal propositions. You can also consider subscribing to my digital law magazine, which is a monthly magazine sent through email. I write about a lot of interesting legal issues with a lot of research. I'm sure it will be useful for you in practice. Thank you. Until next time.